So, good evening class. Tonight's topic will be Title 13 of the Revised Corporation Code of the Philippines. We will be talking about dissolution. So, our source materials for tonight will be Partnerships and Private Corporations by De Leon and De Leon Jr. and also the Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So, dissolution is not a new concept, class, because we already studied this in partnership. They are practically the same concept in both cases. But obviously, there are differences when it comes to the grounds for dissolution. So anyway, please take note, class, of the definition of dissolution. This will signify the extinguishment of corporate franchise and also the termination of corporate existence. Obviously, because it is the state which gives the power to corporations to incorporate. It is also the state who can dissolve corporations. Dahil ang state ang nagbigay ng buhay, ang state then ang pwedeng mag-take away noong life given to the corporations. Now, please take note that corporations can only be dissolved with the consent of the state acting through the Securities and Exchange Commission. In corporate dissolution, remember, there are two legal steps. Number one, kailangang ma-terminate yung corporate existence insofar as the right to go on doing ordinary business is concerned. So, kailangang matapos na yung doing ordinary business. At least in that way. Kasi remember, class, na hindi naman kaagad terminated ang corporation because it has to wind up its affairs. So winding up of affairs, it will consist of payment of the debts, distribution of the assets, and assets among the members or shareholders and other persons interested. So after winding up, dun pa lamang mataterminate yung corporate existence for all intents and purposes. So remember, the methods or causes of corporate dissolution may be voluntary and it may also be involuntary. So the voluntary causes of corporate dissolution are due to majority vote of the BOD or BOT and majority of the stockholders representing the outstanding capital stock, majority of the members in case of non-stock corporations where no creditors are affected. Meaning, walang creditors or at least there is consent of the creditors to dissolve yung corporation. Now, number two, by judgment of the SEC after hearing of a petition for a voluntary dissolution where creditors are affected. So, this will be discussed in Section 135. In 135, the creditor, yung consent ng creditors to dissolve, hindi nakuha ng corporation. So, they will file a petition for voluntary dissolution with the SEC. What else? By amending the Articles of Incorporation to shorten the corporate term, voluntary yan. Number 4, in case of a corporation sold by filing a verified declaration of dissolution with the SEC. So, we already studied that when we talked about Title 13 noong Chapter 2. So, with regard to religious corporations. So, the involuntary methods naman of corporate dissolution are, number 1, expiration of the specific corporate term. Kung hindi perpetual ang corporate term na ang ginawa ng corporation, hindi siya perpetual corporate term or they indicated a fixed term. Now, by expiration of the specific corporate term as provided in the Articles of Incorporation, this is one ground for involuntary dissolution. By legislative enactment, so there is a law which will dissolve yung corporation. Number 3, dissolution by quo warranto proceedings. Number 4, order of the SEC in case of deadlock or mismanagement of closed corporations. Number 5, by the methods of involuntary dissolution under Section 198. So anyway, the methods of dissolution, whether voluntary or involuntary, we will discuss one by one. So the methods of voluntary dissolution, yung una voluntary dissolution where no creditors are affected. So, how is this done? Paano nyo gagawin itong dissolution na ito? So, obviously, if there is voluntary dissolution where no creditors are affected, the dissolution may be initiated by a resolution. So, hindi na kailangan pumunta sa court, hindi na kailangan pumunta sa SEC because it will not affect the rights of the dissolution will not affect the rights of any creditor. So, ang dissolution dito is by a resolution adopted by approved by majority vote of the board of directors or trustees, and then approved also by the affirmative vote of majority of the OCS or members. So majority lamang. So again, in this case, remember, even holders of non-voting shares or non-voting members, as the case may be, are entitled to vote on the matter of dissolution. What else? Number 2, this dissolution shall take effect only upon the issuance of the SEC of a certificate of dissolution. Anyway, you have to file a request for dissolution, obviously, before the SEC can file a certificate of dissolution. What else? In case the corporation is a corporation vested with public interest, it must be accompanied by a favorable recommendation of the appropriate government agency. So yung request for dissolution must be accompanied by a favorable recommendation from the appropriate government agency. So anyway, the procedure for voluntary dissolution under Section 134 are as follows. Number 1, resolution ng majority BOD or BOT, katulad ng sinabi ko kanina. Siyempre, magkakaroon ng meeting para i-approve itong resolution ng mga stockholders and also the members. So, at least 20 days prior to the meeting, kailangan magbigay ng notice to each shareholder or member by personally, by registered mail, or any of the means authorized by the bylaws. So, pwedeng yung mga electronic, remote, etc. as long as it is authorized in the bylaws. Whether or not the stockholder or the member is entitled to vote, kailangan magpadala siya ng notice. So, if merong stockholders with delinquent shares, kailangan pa rin padala ng notice yan, even though they are not entitled to vote. And remember also that non-voting shares, boboto din sila with respect to this topic or proposal. So, kailangan din obviously nabigyan sila ng notice. So anyway, in the notice, kailangan nakalagay ang time, place, and object of the meeting. And remember, the notice of meeting must be published once prior to the date of the meeting. So may publication. Anong ipapublish? Yung notice of meeting. So it must be published in a newspaper in the place where the principal office of the said corporation is located. Kung wala namang dyaryo dun sa lugar na yon, newspaper of general circulation in the Philippines. So what else? Number 3, resolution to dissolve must be approved by majority vote of the stockholders, majority vote of the outstanding capital stock, para madali na lang. And obviously also at least majority of the members in case of non-stock corporation. Now, after na-approve yung resolution ng majority BOD, BOT, at saka majority OCS members, kailangan mag-file ng verified request for dissolution with the SEC. Anong contents? Reason for dissolution, form, manner, time when the notices were given. So, if the notices were given electronically, ilagay nyo kung kailan binigay, time na binigay, etc. Names of the stockholders and directors or members and trustees who approved the dissolution, date, time, and place of the meeting in which the vote was made, and the details of the publication. Details of the publication of the notice of meeting. So, kailangan yung ilagay kailan ba pinablish yung notice of meeting, anong dyaryo, etc., etc. Details of publication. So, obviously, after that, the corporation shall submit the following to the SEC in addition to the verified request for dissolution. Kailangan kasama niyan ang copy ng mismong resolution authorizing the dissolution. Remember, certified by majority of the board of directors or trustees and countersigned by the secretary of the corporation. Proof of publication. Usually the proof of publication is the newspaper itself and also an affidavit of publication by the publisher. And obviously, the favorable recommendation from the appropriate regulatory or government agency whenever it is necessary. What else? Submit to the SEC yung verified request for dissolution, resolution, and other accompanying documents. Tapos, within 15 days from the receipt of the request for dissolution, if hindi withdraw, the SEC will approve the request for dissolution and issue a certificate of dissolution. So, pagkatanggap niya ng lahat ng requirements, kailangan, tapos hindi withdraw yung request within 15 days from the receipt, remember class, kailangan i-approve at ang i-issue ng SECI, Certificate of Dissolution. So, yun ang tandaan natin sa voluntary dissolution where there are no creditors affected under 134. Now, how about if there are creditors affected? So, again, this dissolution contemplates a situation where the consent of the creditors to dissolve the corporation cannot be obtained. So, hindi makuha ang consent ng mga creditors para mag-dissolve ang corporation na to. This is initiated by a petition filed with the SEC. And remember, the SEC after due notice and hearing shall render judgment. So, remember, 134 is initiated by a resolution. 135 is initiated by a petition. So, ayan pala, kakasabi ko lang. So, anyway, initiated by a petition filed with the SEC. SEC will render judgment after due notice and hearing. So, pagka nag-hearing na, the SEC, if it finds that the petition is in order, tapos kung meron mga objections, ni-resolve naman niya, it will render judgment dissolving the corporation. And it will direct the disposition of assets. Also, SEC may appoint a receiver to collect such assets and pay the debts of the corporation, or in summary nga, take charge of the liquidation. So, pwede ang corporation na ang mag-dispose ng kanyang assets, etc. Or pwedeng mag-appoint ang SEC ng receiver to liquidate yung corporation. So, remember that the dissolution shall take effect only upon the issuance of a certificate of dissolution. So, kung walang certificate of dissolution, hindi madi-dissolve ang corporation under 135. So, procedure, petition for dissolution. Kung 134 resolution, ito petition. So, the petition for dissolution shall be drafted by a majority of the BOD and signed by the majority of the BOD or trustees, verified by the president or secretary or one of the directors or trustees. And, very important, it shall set forth all claims and demands against the corporation. So, ilagay nyo dyan, ito si A may utang sa amin, ito si B may utang kami sa kanya, etc. etc. So, yun ang ilalagay sa petition for dissolution. So, in addition to that, the reason for the dissolution, kailangan ilagay, form, manner, and time when notices were given. Because remember here, class, again, yung petition kailangang ipa-approve. So, sa mga stockholders, members, so kailangan may meeting na naman. So, what else? Number 3, date, place, and time of the meeting in which the vote was made. And number 4, may number 4 pa. Wala na pala. Tatlo lang pala. Sorry class. So, anyway, accompanying documents to the petition. So, in addition to the petition na nandun yung mga contents na sinabi ko, kailangan pa ang mga documents na to. Number 1, copy of the resolution authorizing the dissolution certified by a majority of the BOD or BOT countersigned by the secretary of the corporation. Because obviously, before you will draft the petition for dissolution, meron namang resolution ang mga directors na i-dissolve yung corporation. The only difference is that yung resolution na to hanggang sa mga directors lang tsaka trustees. They do not submit it to the stockholders or members for approval. Kasi ang isasubmit nila is yung petition. Yan. So ang resolution na to is mag-dissolve na tayo, draft na tayo ng petition. Tapos yung petition na yun ang i-approve ng mga stockholders. In 134, remember, it is exactly the resolution to dissolve which will be approved by the stockholders. So what else? Number 2, a list of all the creditors. Because remember, in the petition, you have to set forth all claims and demands against the corporation. So what else? Number 2 step, meeting of the stockholders or members called for the purpose. So, and during the meeting, approval of the petition. Sabi ko nga sa inyo, petition ang pinapa-approve for dissolution by the two-thirds vote of the OCS or two-thirds of the members. So again, the difference. In case of 134, majority lamang. Pagdating sa stockholders, members, pagdating sa 135, yung petition must be approved by two-thirds OCS, two-thirds members. What else? Submit to the SEC yung petition for dissolution. If the petition is sufficient in form and substance, the SEC shall by an order reciting the purpose of the petition, fix a deadline for filing of objections. Yan. So, in short, mag-i-issue ang SEC ng order. The order will state the purpose of the petition. So obviously, the purpose of the petition is to dissolve the corporation. Tapos dun sa order na yan, may nakalagay din na date. Ano yung date na yon? Deadline for filing of objections to the petition. Bakit? Sino bang mag-object sa petition? Di yung mga creditors na nung una pa lang hindi nakuha yung consent nila para mag-dissolve. So remember, the date shall not be less than 30 days nor more than 60 days after the entry of the order. So let us say, final sa SEC yung petition for dissolution, tapos nagkaroon ng order. So yung date ng order, yung setting, yung date for deadline for the filing of the objections. Let us say today, pinasok yung order. Doon ginawa ng SEC yung order today. Today is November 25. Today is November 25. So ito yung date ng entry ng order ng SEC. Entry ng order, ginawa nila yung order. Ganun lang yun, simple. So yung deadline date for filing of objections to the petition shall be sometime between December 25 to may 31 yung December, no? January 24, 2021. So you can set a date doon sa in between those dates. So yung period in between December 25, 2020 and January 24, 2021, you can set a date. The SEC pala will set a date for the deadline for filing of objections. So let us say, class, the date set by the SEC is, susulat ko, baka makalimutan ko yung example ko January 15, 2021. So that is the deadline set by the SEC for the filing of objection. So anyway, before the set date, January 15, 2021, based on my example, a copy of the order shall be published at least once a week for 3 consecutive weeks. 3 beses ipapublish, pero once a week lang, in a newspaper of general circulation in the city or municipality where the principal office of the corporation is situated. Ang napaka-wordy talaga ng corporation law, no? Bago ko newspaper lang, ang dami ko pang sinabi. So, in case there is no newspaper in that location, newspaper of general circulation. In addition to publication, meron pang posting in 3 public places in such city or municipality. So, similar copy of the order will be posted for 3 consecutive weeks in 3 public places in the city or municipality where the corporation is located. So, publication na meron pang posting para siguradong mabasa ng mga creditors yan na gustong mag-object. And remember, the deadline for objection is January 15, 2021. So, pagka-expire noong deadline para magbigay ng objection. So, syempre, maghihearing ang SEC. Now, if the SEC will set a date for hearing, let us say March 15 ang sinet nila na hearing. Pwede naman sila mag-hearing kung kailan nila trip, wala namang binigay na period. So March 15, 2021, that is the date for the hearing of the petition. Wala namang prescribe kung kailan dapat, wala namang inclusive dates na prescribe kung kailan dapat ang hearing. So let us just say March 15, 2021. So remember, 5 days notice, kailangang magbigay at least 5 days notice. So bago mag March 15, dapat meron at upon 5 days notice, magbigay ng notice doon sa mga creditors or any person who wants to file an objection. Kailangan meron silang notice na at least 5 days. So parang sasabihin niya sa mga creditors, ito March 15 maghi-hearing na ako, bibigyan niya ng notice yan at least 5 days before. So at least yung mga creditors can attend the hearing. So anyway, the SEC will hear the petition and try any issue raised in the objections of the creditors. And if the objections are not sufficient and the material allegations of the petition are true, it will render judgment dissolving the corporation and direct the disposition of assets. Also, again, the SEC may appoint a receiver to collect such assets and pay the debts of the corporation. So, yun ang method for voluntary dissolution where creditors are affected. What else? There can also be dissolution by shortening of the corporate term. So, this is affected by amendment of the Articles of Incorporation. And remember, such amended Articles of Incorporation are submitted to the SEC. So this is also in relation to Section 15 because Section 15 talks about amendment. So upon approval of the SEC of the amended articles na mayroong shortened term, or by expiration of the shortened term as the case may be, the corporation shall be deemed dissolved without any further proceedings except to liquidate. So, remember class, in section, dissolution by shortening corporate term under 136, ang kailangan yung tandaan dyan is that, only upon approval by the SEC is the corporation deemed dissolved. So, kung walang approval ng SEC, hindi madi-dissolve yung corporation. Kailangan niyang i-approve yung Articles of Incorporation. Now, if you remember Section 15, di ba sabi doon, kailan ba effective ang mga amendments? Effective ang amendments kapag in-approve yan ng SEC. Malinaw yon. Also, meron din tayo dun sa last paragraph ng Section 15, the amendments will also become effective from the date of filing with the SEC if not acted upon within 6 months from the date of filing for a cause not attributable to the corporation. So, ang ibig sabihin lang yan, nag-file ka ng amended articles, hindi inaktuhan ng SEC within 6 months from the date of filing. You filed today, 6 months na, hindi pa inaaktuhan ng SEC. Remember class that your amendment will become effective not from the date na na-reach niya yung 6 months, not that, but from the date of filing. It will retroact to the date of filing. So, yun ang tandaan nyo. This is what they call the automatic approval provision under Section 15 of the Revised Corporation Code of the Philippines. Now, matapos kong sinabi lahat yun, remember class, the automatic approval provision under Section 15 does not apply to Section 136. Wala lang, trip ko lang sabihin, i-discuss tapos sabihin ko na hindi siya mag-a-apply. Remember here, the law is very strict. The amendment to shorten corporate term under 136 must be approved by the SEC. So, kailangan mag-comply siya with the formalities of law because dissolution can only be done with the approval of the SEC. What else? Galing ko mang inis, no? Publication of the notice of dissolution. So, affidavit of publication of the notice of dissolution must be executed by the publisher of the newspaper. Hindi pwedeng walang publication ng notice of dissolution. So, kailangan mag-submit kayo ng publisher's affidavit or affidavit of publication. So, it is, even though not expressly required under 136, kailangan daw yan according to SEC Opinion, August 30, 1988. Yan. What else? Section 137, the rules regarding withdrawal of the request for dissolution. So remember, this will be related to Section 134. So yung 134 is voluntary dissolution where there are no creditors affected. Remember, it is initiated by a resolution. Afterwards, you will file a verified request for dissolution with the SEC. Now, what you have to remember, according to 137, you can withdraw your request for dissolution. So, the withdrawal for request for dissolution shall be made in writing, verified by any incorporator, director, trustee, etc., etc., and signed by the same number of incorporators, directors, trustees, etc., necessary to request for dissolution as set forth in Section 134 of the Revised Corporation Code of the Philippines. Also, although this is not indicated very clearly, because there is no necessary number to request for a dissolution, but a necessary number to approve the resolution is majority. So probably this is majority of the majority vote of the stockholders members and also majority vote of the directors or trustees. Hindi kasi masyadong nilinaw ng SEC yan, ng Revised Corporation Code yan. What else? Number 2, withdrawal shall be submitted no later than 15 days from the receipt by the SEC of the request for dissolution. Remember, the approval for the request for dissolution is, according to Section 134, is within 15 days. Yan. So, within 15 days from the receipt of the request of the dissolution, the SEC must approve it. So, kailangan, bago i-approve ng SEC, ma-file nyo na yung withdrawal. This is the reason why it shall be submitted no later than 15 days. Kailangan yung habulin bago ma-approve ng SEC yung request for dissolution. What else? Upon receipt of the withdrawal of request for dissolution, the SEC shall withhold action doon sa request. So, di ba meron kayong pending na request for dissolution doon? Stop mo na yan. Withhold muna nila yung action dyan. Huwag nilang aktuhan. But instead, because there is a withdrawal of that request, kailangan magkaroon ng investigation. So, after investigation, the SEC will make a pronouncement that the request for dissolution is deemed withdrawn. It may also direct a joint meeting of the board of directors or trustees and the stockholders or members for the purpose of ascertaining whether or not to proceed with dissolution. Ano ba talaga? Tuloy ba to or hindi? Nag-file kayo ng request for dissolution, tapos withdraw nyo yung request nyo, etc. etc. And also, the SEC may issue such other orders as it may deem appropriate. So, remember, rules regarding the withdrawal of request for dissolution. Paano naman yung if your dissolution is initiated by petition sa SEC. So, obviously, you can also withdraw your petition for dissolution which you have filed under Section 135. So, sabi sa 137, ang withdrawal of petition for dissolution shall be in the form of a motion and with similar in substance to a withdrawal of request for dissolution. But remember, this must be verified with a motion to withdraw petition for dissolution, and it must be filed prior to the publication of the order setting the deadline for the filing of objections to the petition. So remember, in 135, di ba pagkatanggap ng SEC ng petition for dissolution together with the accompanying documents, mag-i-issue siya ng order, di ba, which will recite the purpose of the petition. So dun sa order na yon, dapat mahabol mo yon. Bago mag-issue ang SEC ng order, dapat ma-file mo yung motion mo. So, yun ang kailangan yung tandaan, habulin yung order. So, yan ang withdrawal. Methods naman of involuntary dissolution. So, dissolution by expiration of a term. So, this is affected by the expiration of the period as fixed in the original articles of incorporation and there is no extension. So, hindi nyo in-extend yung corporate term. But obviously, class, pagka in-extend yung corporate term, walang dissolution. Pero, kung halimbawang na-dissolve na talaga, the corporation is no longer de facto or de jure. And remember, will exist only for purposes of winding up or liquidation. So, hindi na pwedeng i-extend pagka na-dissolve na. Pero, obviously, the stockholders can reincorporate yung expired corporation by starting anew and complying with the requirements for incorporation under sections 13 to 14. Ulitin ko, hindi na pwedeng i-extend yung corporate term ng corporation na nag-expire na yung term. Ano pang i-extend mo? Wala na nga, tapos na. Pero pwede kang mag-reincorporate. Now, if you do not extend the corporate term, obviously the corporation is dissolved by expiration of term. What else? Dissolution by legislative enactment. So remember, the Congress has reserved power to dissolve corporations. This is impliedly given by Section 184, which we will discuss later on. So please take note of the limitations on the power to dissolve corporations by legislative enactment. Sabi dito, in case of a public utility, the Congress can amend, alter, or repeal yung corporate franchise of a public utility only when common good so requires. So, if common good will be served by the amendment, alteration, or repeal of the franchise of a public utility, doon lang siya pwedeng i-dissolve by legislative enactment. Also, please take note of Section 184, as I've already said a while ago. No right or remedy in favor of or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by any such corporation, stockholders, members, directors, trustees, or officers shall be removed or impaired either by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of this code or any part thereof. So, obviously, the Congress will have the right to dissolve yung corporation according to 184. So, and also, the Congress can subsequently also amend or repeal yung revised corporation code. But in 184, remember, sabi niya, if there are already existing rights or remedies in favor or against a corporation, and also there are existing liabilities of such corporation, etc., it cannot be removed or impaired. So, in short, if there are existing or vested rights and there are already existing obligations, hindi basta-bastang dissolved by legislative enactment ang isang corporation. What else? Dissolution by quo warranto proceedings. So, this is again implied in Section 19. Remember in Section 19 when we discussed de facto corporations, diniscuss din natin yung quo warranto proceedings. Anyway, Solicitor General is authorized to bring quo warranto proceedings against a de facto corporation. So, a de facto corporation is a corporation na mayroong defect yung kanyang incorporation, but it has been issued a certificate of incorporation. And remember, it exercised in good faith corporate powers. So, with respect to third persons and actually to everybody, yung isang de facto corporation is corporation talaga. Meron siyang juridical personality. Except with respect to the state. So, ang state can question or attack directly yung franchise ng isang de facto corporation. Now, the direct attack to question the corporate franchise of a de facto is called quo warranto. So, again, class, tinanong ko sa inyo, saan fina-file ang quo warranto proceedings? I hope you already have the answer. I will ask on Saturday where obviously alam nyo na it is the Solicitor General who files a quo warranto proceedings, but sino ang may jurisdiction? Is it the SEC or the RTC? Saan mo ba ipa-file ang quo warranto proceedings? So, I hope you already know the answer. I will ask you class on Saturday. So, what else? Deadlocks and mismanagement of a closed corporation. We have just recently discussed this. So, in case of deadlock, so yung deadlock, yung management is so divided that they cannot pass any action they cannot approve any action para sa good ng corporation. So, kung nagkaroon na ng deadlock, so any stockholder may file a written petition to the SEC. SEC will have the authority or power to arbitrate the dispute, to cancel any order, cancel any resolution, to ask parang direct yung stockholder or the corporation to buy yung shares ng isa sa mga stockholders. Anyway, one of the powers also of the SEC in case of deadlocks is to dissolve yung corporation. This is under Section 103. So, in case naman of mismanagement under Section 104, any stockholder again may file a written petition to the SEC for dissolution. If there are acts of the directors, officers, or those in control of the corporation which are illegal or fraudulent or dishonest or oppressive or unfair to the corporation or any stockholder, and or whenever corporate assets are misapplied or wasted. So in short, if there is mismanagement of the corporation, pwedeng mag-file ng written petition ang isang stockholder sa closed corporation para magkaroon ng dissolution. So, what else? Involuntary dissolution under Section 138. So, in case of involuntary dissolution under 138, what you have to remember is that SEC may dissolve corporation motu proprio or on its own discretion. So, sa sarili niyang initiative or upon the filing of a verified complaint of any interested party. So, remember also that in involuntary dissolution, pagka nagkaroon ng dissolution by final judgment, pursuant to the grounds under Section 138, yung assets ng corporation after all the liabilities have been paid will be forfeited in favor of the national government. So, obviously, yung forfeiture is without prejudice to the rights of innocent stockholders and employees for services rendered. So, bigay nyo yung sa mga empleyado, bibigay ng SEC, yung mga para sa empleyado, and also para sa mga innocent stockholders. Because remember here, involuntary dissolution under 138 is based on some violation of the corporation. So, kailangan yung mga wala namang kinalaman sa violation, they will not be prejudiced. So, yun ang tandaan natin. Anyway, the assets of the corporation ngayon will be forfeited in favor of the national government. Imbis na ibalik sa mga guilty directors, trustees, officers, stockholders, members, it will be forfeited in favor of the national government. Yan. What else? Corporations under regulatory agencies. So, obviously, SEC will also coordinate with itong mga appropriate regulatory agency na ito before the involuntary dissolution of the companies of the corporations under Section 138. So anyway, grounds for involuntary dissolution under this provision: non-use of the corporate charter and failure to formally organize and commence its business within 5 years from the date of incorporation. So, pagka naman kasi hindi nakapag formally organize ang isang corporation, paano ba nag-formally organize ang isang corporation? By construction of works, election of yung kanilang mga officers, etc., etc. Kailangan nilang magawa yan within 5 years from the issuance of the certificate of incorporation. If they fail to do that within 5 years from the date of incorporation, certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period, except when the failure is due to causes beyond the control of the corporation. So, pagka-issue ng certificate of incorporation, kailangan mag-formally organize ang corporation and it must commence the transaction of its business. Formally organized by, alam mo na, electing yung kanilang officers, directors, etc. Tapos yung commence the transaction of its business, mag-rent na sila ng place, etc. Yung mga acts na to yung indicate na nag-uumpisa na sila ng kanilang business. So, meron silang 5 years para gawin yan. Kung hindi nila nagawa yan, kung halimbawa 5th year today, after the issuance of the certificate of incorporation, mare-revoke na siya kinabukasan. So, kung na-issue ngayon, nagbilang ng 5 years, last day ngayon ng 5-year period na yan, kinabukasan, yung kanyang certificate of incorporation shall be revoked. Remember, as of the day following the end of the 5-year period, except if the failure is beyond the control of the corporation. Remember, class, if sige, mamaya ko na i-discuss yan pagka sa na lang, sa klase na lang natin. What else? Number 2, continues in operation of a corporation for a period of at least 5 consecutive years. And not only that, there is a failure to cause the lifting of delinquent status. So, continues in operation for a period of 5 consecutive years. Hindi naman talaga yan ground for dissolution. But it will be a ground to place the corporation under delinquent status. But only after due notice and hearing. May hearing pa yan. Hindi rin matik yan. Kung nag-hearing, tapos, ayan, hindi kontento ang SEC sa explanation, it can place the corporation under delinquent status. Now, a delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements of the SEC. Pagka na-comply na nila, within the period given, SEC shall issue an order lifting yung delinquent status of the corporation. Now, if you fail to submit all the requirements of the SEC, you fail to resume operations within a period of 2 years. Remember, class, yung SEC shall cause the revocation of the corporation certificate of incorporation. Dun pa lang ma-dissolve yung corporation. If you fail to cause the lifting of the delinquent status within the period provided by law. So upon receipt of a lawful order, court order dissolving the corporation, what else? Upon finding by final judgment that the corporation procured its incorporation through fraud. So, nung nag-incorporate sila, there is already a fraud. Remember, class, that this must be by final judgment. Yan, yung finding na yan before the corporation is dissolved. Also, upon finding by final judgment that the corporation is, number 1, created for the purpose of committing, concealing, or aiding in the commission of securities violations, smuggling, tax evasion, etc., money laundering, or graft and corrupt practices. Number 2, yung corporation committed or aided in the commission of securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices, and alam ng mga stockholders yan. And number 3, repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by the directors, trustees, officers, or employees. So, again, this is by final judgment. So, obviously, there is a hearing to determine whether or not this applies to the corporation. What else? The effects of dissolution. Number 1, corporation ceases as a body corporate to continue the business for which it was established. Hindi na pwedeng mag-business. Ang kanilang mga transactions na lang is for winding up or liquidation. So, it will continue as a body corporate, not for the transaction of business, but for winding up or liquidation for a period of 3 years. What else? Upon expiration of the winding up period of 3 years, the corporation ceases to exist for all lawful purposes and as a general rule can no longer be sued as such. How about a corporate liquidation? In corporate liquidation, remember, winding up of affairs of the corporation by reducing assets to money, settling with creditors and debtors, and apportioning the amount of profits and losses. So, in liquidation, remember, it will consist of adjusting all debts and claims and collecting all that is due to the dissolved corporation. Also, it will include settlement and adjustment of the claims against the corporation and payment of the debts. So, methods of corporate liquidation. Corporation can liquidate its affairs by itself. Corporation can appoint a corporation can be liquidated by a duly appointed receiver. So it is the SEC who will appoint, or the courts who will appoint a receiver. What else? Liquidation by a trustee to whom the corporation had conveyed corporate assets. So liquidation by the corporation itself. So remember, this is done through the directors or trustees or executive officers who are in charge of the winding up of operations. So yun ang normal method daw or procedure. Ang mga directors or trustees, executive officers ang magwa-wind up ng operations ng corporation. So, corporation will remain as a body corporate for 3 years after the dissolution, only for the purpose of settling its affairs, para sa winding up lang. So, this will include prosecuting and defending suits by or against it, enabling it to settle and close its affairs, dispose and convey property, distribute assets, etc., etc., but of course not to continue business. Remember, class, if ikaw ay creditor, you fail to present your claims against the corporation and you failed, yung claim mo hindi na settle within the 3-year period, your claim will become unenforceable kasi wala ng corporate entity against which it can be enforced. However, obviously, you can file your claims against the liquidator after the lapse of the 3-year winding up period. What else? Liquidation by a receiver. So the SEC is authorized to appoint a receiver to collect assets of the corporation, pay the debts of the corporation. Courts are also empowered to appoint a receiver. So receivership is indefinite until all the affairs of the dissolved corporation have been settled. So until hanggang nandiyan pa yung anyway, because the receivership is indefinite, pwedeng i-present yung claims mo as long as it is not barred by the statute of limitations, meaning hindi pa siya nag-prescribe. So here, the 3-year period under 139 is not applicable. Appointment of a receiver is discretionary with the court and the SEC. Bahala ang SEC if it will appoint a receiver, or the court, bahala siya kung siya ay mag-a-appoint ng receiver. What else? Corporate directors are guilty of breach of trust. Minority stockholders may also ask for receivership. So, in case of appointment of a receiver, yung authority ng corporation to over the property and effects of the corporation is suspended yan. Tapos, ito ay ibibigay sa isang receiver. So, yun ang kailangan nating tandaan. Suspended ang authority ng mga officers, directors, and ibibigay ito sa receiver. So, ang receiver na ang bahala sa pagsisettle ng affairs ng corporation. So, what else? Liquidation by trustees. So, to whom the directors or trustees conveyed yung corporate assets. So, ipapasa nila sa iba. They will, itong mga pinagpasahan nila, they will be called your trustees. And yung corporation, stockholders, directors, trustees, members, etc. will be called the trustor. So, sila yung nagkatiwala sa isang trustee na siya ang mamamahala dun sa corporate assets. So, yung trustee sa non-stock corporation is different from a trustee in a trust agreement. Remember. Anyway, liquidation may be placed in the hands of a trustee or assignee to whom the corporate assets are conveyed. So, all the assets of the corporation are given to a trustee. Again, yung trustee dito is different from a trustee in a non-stock corporation. Basta yung trustee na pinag-usapan natin dito, ibibigay lahat ng corporate assets sa kanya. So, anytime during the 3-year liquidating period, so kailangan makapag-appoint ka ng trustee during the 3-year liquidating period. So, all of the corporate properties will be conveyed or given to the trustees for the benefit of the stockholders, members, creditors, or other person in interest. So, trustee will become the legal owner, beneficial owner naman yung mga creditors, stockholders, or members and other interested persons. Yan. Trustees will exist indefinitely hanggang sa nabayaran lahat ng utang ng corporation, na settle lahat ng affairs. Again, 3-year limitation does not apply. What else? To distribute corporate assets. So, exceptions in Section 37 and as otherwise allowed by the Revised Corporation Code under Sections 8, 9, 40, 42, 103, and 104, no corporation shall distribute any of its assets except upon lawful dissolution after payment of all debts and liabilities. Bayaran mo muna lahat ng debts and liabilities and mag-dissolve muna bago i-distribute yung assets or property ng corporation except as otherwise provided in the exceptions I have just mentioned. If hindi ginawa ito, this is in violation of the trust fund doctrine. So, pinag-aralan natin yung trust fund doctrine under, I think, Section 40, just for starters, pinag-aralan pa rin natin yan sa Title 7, yung Trust Fund Doctrine. So anyway, it considers the subscribed capital as trust fund or equity in trust for payments of debts of the corporation to which the creditors look for satisfaction. So until there is liquidation of the corporation, obviously, bago mag-liquidation, may dissolution muna. No part of the subscribed capital may be returned or released to the stockholder except in cases of redeemable shares without violating yung principle ng trust fund doctrine. Yan. Anyway, in the application of assets, wala tayong problema if the assets are sufficient to defray all the liabilities. Kung mababayaran lahat ng liabilities, wala nang priority kasi mababayaran lahat. Pero nagkakaroon lang ng significance yung priority of payment if the assets are not sufficient to pay all the claims. So anyway, pagka priority, ang unang babayaran, creditors according to the rights and priorities, stockholders members, etc., who are also creditors because nangutang sa kanila yung corporation. What else? The remaining assets to be distributed among the stockholders or members in proportion to their shareholdings. So babalik na yung mga shareholdings or interest in the absence of any provision to the contrary. Again, holders of preferred stock as to assets have preference over common stockholder in the distribution of surplus profits of the dissolved corporation, except as otherwise provided in 93 and 94 in case of distribution of assets of non-stock corporations. Remember, 93 is yung order of priority in the distribution of the assets of a non-stock corporation. In section 94, this talks about the plan of distribution. So anyway, any asset distributable to any creditor or stockholder who is unknown. So meron tayong asset na kailangang ibibigay sa isang creditor or stockholder. Merong utang na kailangang ibayad sa creditor. Merong asset na kailangang ibigay sa stockholder or member. Because remember, merong mga assets which can be returned to the members. Allowed naman yan eh. If such creditor, stockholder, or member is unknown or cannot be found, it shall be escheated in favor of the national government. Escheat is, proceeding siya class. In case na wala kang heirs, ganyan, namatay ka nang wala kang mga kamag-anak, saan mapupunta yung property mo? It will be escheated in favor of the government. So, yun ang kailangan yung tandaan. So, hindi pwedeng i-distribute yung mga assets or assets belonging to creditors, stockholders, or members na or na unknown or cannot be found because this will violate yung trust fund doctrine. Yan. So, what else? Until the liquidation of the corporation, the subscribed capital cannot be returned or distributed to the stockholders pursuant to the trust fund doctrine. So, yun ang kailangan nating tandaan when it comes to corporate liquidation. So, anyway, class, that's it for Title 14 of of the Revised Corporation Code. Sabi ko sana your book, pero kasi nag-iba na rin yung mga titles because I believe you are still using the old book by De Leon and De Leon Jr. Wala pa kasi silang update. Nananawagan po ako sana mag-update na sila. So anyway, kung hindi, we will continue using this book even up to next year. Probably, mas nahihirapan lang kasi kayo. So anyway, please stand by for Title 15. This will talk about foreign corporations. So anyway, good night class and thank you.